rise. Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. Good morning. This is the time set for argument in Dream Games of Arizona versus TARP Holdings et al. Our case number CACV 190789. Each side will have 20 minutes for argument. Appellants can reserve whatever time they'd like for rebuttal, but you'll be responsible for just keeping track of your own time on that. These proceedings are being video recorded. We would ask that you identify yourself and your client when you begin the argument, just for ease in matching names with voices for people who are listening to a recording. We have read the briefs. We've conferenced this matter. And we're looking forward to hearing from both sides. And with that, counsel, you may begin.
Good morning, Your Honors. David Cantelme with Aaron Brown and Kelsey Spillers appearing this morning on behalf of appellants, cross-appellees, Dream Games, and American Software. May I clarify, Your Honor, that it's okay to speak without a mask?
Yes, unless there's
no objection.
A concern with anyone at counsel's table, we also will be have removed ours, as you can see. Thank you.
Just want to make sure I observe protocol properly. Your Honors, I have 5 main points to make this morning. I'm going to summarize them and then I'll develop them as I go. I'm going to try to make my opening presentation in 15 minutes and say 5 for rebuttal, and I will try to manage my clock in doing so. 5 main points. 1, invited error. 2, even if it were error, it's not fundamental under these circumstances and cause no prejudice. 3, turning to valuation, ample evidence supported the damages that were awarded in the trial court. And last, I missed one. Duncan's opinion regarding income streams was admissible. It was properly formulated. No Daubert challenge was made to it. And under all the circumstances, and I think that's what you have to consider is all the circumstances, this case arises out of contract and award of fees was proper below. Let me start with invited error. If you have an occasion, I would invite the court, you probably already have, but just to emphasize the point, to look at the appendix, volume 1, pages 70, which is the instruction, the red line that had been submitted by defendants, and compare it to the instruction actually given, which is in page 78 of volume 1 of the appendix. And you will see, Your Honors, that essentially the trial court gave the instruction requested by defendants. She rearranged it a little bit, but the wording was essentially the same. And what she rearranged is she took a phrase, something an individual defendant did had a negative effect on plaintiff's ability to collect. She took that from where defendants had put it and made it an element of the conspiracy claim. It's not an element of the conspiracy claim, but that's what she did. The argument is made that this was inadvertent. It was a mistake, that counsel would never have submitted such an argument knowingly. Well, the fact is, Your Honors, we don't know what was in counsel's mind. That's a subjective fact, and it was never established in the record what he was thinking or wasn't thinking.
Counsel, but wasn't there a specific written objection to that particular standard?
Partly, and here's why I say partly. Conspiracy's got 4 elements. The specific objection which came in the filing that was made on April 3 by defendants said that the clear and convincing standard applied to proving the agreement, the conspiracy agreement. That's only one element. And that's all he said clear and convincing applied to. And then he retreated from it. And where did he retreat from? Well, first off, 2 days later on April 5, and bear in mind, Your Honor, we're in the heat of trial. Mr. Brown and I tried it, Mr. Littler tried it, and as the court is well aware, you have many balls in the air when you're in trial. But the fact is, when you look at the instruction he submitted, he finished her thought. He added, Your Honors, after she wrote, more probably true, he added, then not. He added those two words, and that could not have been inadvertent, because it does, in fact, complete the thought.
But you're saying that does away with the earlier objection to the
Absolutely.
verdict?
Yes. He retreats from the objection, he abandons it, and let me give a little bit of the history of it, or the chronology, because I think it puts it all in perspective. We submit our proposed instructions on March 2. Trial begins, I think, March 15, something like that, maybe March 5, but there was a week interlude. Trial goes on for 20 days. We submit our proposed instructions. We submit the conspiracy. We submit clear and convincing. We don't say what clear and convincing applies to. On April 3, the represented defendants first submit their anything that they have to say at all with respect to whether clear and convincing applies to conspiracy. Never weighed in on that before then. Now, Mr. Littler, representing TARP and 24 Circle, in fact had circulated comments that would have applied clear and convincing, but he never filed those. We, on March 2, filed a response to what Mr. Littler had never filed. We didn't realize in heat and press of trial prep that he never actually filed it with the clerk, although he had circulated it to counsel. April 3, in the meantime, the judge circulates her own proposed instructions and asks for counsel to give red line back, showing what we agree to, what we disagree to, what should be added. And that's what happens on April 5. Defendants submit their instruction that adds than not. And it adopts her instruction with modifications, additions, deletions. If you look at the red line, which I actually printed in color for you in the appendix, there's red all over that page because of the deletions. So yes, he absolutely adopted it, and he submitted it to her, and she basically gave his instruction.
Counsel, let me ask you, this is an unusual invited error case, because a prototypical invited error case, the trial judge never gets to fix it. It just comes to us, and then there's a claim that there was an error.
Right.
And the answer is, well, no, you didn't. You said this was just fine.
Right.
Here, though, we have a case where a lot of things happened at trial, as
Yes.
happens at trial.
Right.
But then the trial court says, wait a minute. At the 13th hour, wouldn't have been a happy moment for the trial judge, saying, I made a mistake, and that mistake mattered. And the record could sort of, support a lot of different ways as to how that came to the court's attention. But what case is your best case for the proposition that invited error applies in this context, where the trial judge herself spotted the error, attempted to fix it, and then comes the appeal?
Well, Your Honor, I would say the best case that we have on invited error, turn to my outline. I'm going to give you three because I think you have to read them together.
I'm writing quick, so.
Escalante, Logan, and Robertson. And I think Robertson is the most recent. It's Supreme Court of Arizona. It summarizes the law on invited error. And it tells you exactly what formula you have to follow and how to get there. But let me make a point on that, Your Honor, because you raise a great point. And it goes, in essence, to the heart of the invited error argument, because you have the trial court telling you, I made a mistake. And if I were in your shoes, I would look at that, as you are. The facts don't change. The facts are in the record. What was submitted, what happened, all that is black and white. What matters, Your Honor, is the legal conclusions to be drawn from that, and those are reviewed de novo. And she erred, respectfully, in the conclusions that she drew. I think she felt bad. I'll give you that. In fact, I think she felt really bad about it, because she knows all the effort that went into this. Was a 20-day trial. This was a huge production. It took 3 years to get to trial.
And she was there for every day, as were others, to be sure.
She was indeed.
What-
But recall, Your Honor, when she made that comment, that's a year and a quarter after the actual trial.
Understand.
So
Let me ask you though, what of the cases that you've cited, did any of those involve a situation where the trial court, after the error, tried to fix the error, and then the appellate court?
no, I don't think so,
Okay,
Your Honor.
I recall them the same way, but I haven't read them this morning. So.
To be quite candid, I have not found a case on all fours. That doesn't mean what I have found and submitted to the court is not dispositive.
Understand.
And is
Your Honor.
there no obligation on the part of, on both sides to correct an incorrect burden of proof?
Yes, I would say.
I guess because I'm not
Let
following.
me rephrase that, Your Honor, if I may,
Okay,
so I can
sure.
answer it directly, please. We could not knowingly allow the trial court to commit error. We're duty bound to call it to her attention. And again, you have to keep in mind how this comes about. So the hearing on the instructions, she convenes at 7:30 in the morning on the day she's going to charge the jury. And many things are going on there. All counsel have many things on their mind, as does the trial judge. I can't say, and I'm not going to say, that anybody deliberately let her go forward with that, knowing it was a mistake. I don't say that. I know I did not do that. And I'm not accusing counsel of having done that.
And what would the incentive be for counsel to go forward with an incorrect burden of proof
Well,
that's not helpful to
Your Honor, that's obvious. And to me, in retrospect, it's quite obvious. The case was going very badly against them. They were losing that case at that time, as reflected in the fact that they got hit by huge punitive damages. So you're asking me to speculate. I don't know what was in his head. I really don't, and I'm not going to cast aspersions, but you're asking a theoretical question. Why would somebody do that? The answer that I could give you is it's the poison pill. It's the hedge. It's not something somebody would do if the case was going well for them. I will grant you that. You would never infect error into a case knowing that nobody knows what a jury's going to do. I mean, I've been there before. I thought a jury was coming a certain way, and you don't know until they actually decide. But you do have a feel, Your Honor, as a case goes, how the tides are going in the case. And the feel at that point was it was going badly for defendants. And in fact, did go badly for defendants. So that's, unless you have other questions in invited error, I've got to move on in order to get all my points in. Fundamental error. The point is here, Your Honor, if you look at the elements of what had to be proven, and you've put in a chart what had to be proven for conspiracy versus what had to be proven for fraudulent transfer and punitive damages. If you do that, as I have done, you will see that all of the elements for a conspiracy, with the exception of agreement, and I will come to that, had to be proven to establish fraudulent transfer and punitive damage. Now, to wit, In conspiracy, there must be an agreement, which I will come to as I said, but the agreement is to accomplish an unlawful purpose. Okay? What is the unlawful purpose? Fraudulent transfer. Fraudulent transfer is proven by clear and convincing evidence. Second, actually it's the third element of conspiracy, wrongful acts committed. What were the wrongful acts? The actual transfers, the fraudulent transfers, again proven by clear and convincing evidence. Next element for conspiracy, something the individual defendant did had a negative effect on plaintiff's ability to collect. Now, I don't agree that that's an element to conspiracy, but that is what defendants asked the trial judge to insert, and she did. But it's found. It's established in the constructive fraud, in the fraudulent transfer, and that is actual intent to hinder, delay, or defraud is an element to fraudulent transfer, and it was proven by clear and convincing evidence. Of course, the last element is damages. Damages were proven by clear and convincing evidence for fraudulent transfer, and therefore they're established for conspiracy. They're identical with the exception of agreement. Now, as the court is well aware, there are many cases that say very rarely do you have direct evidence of an agreement, conspiracy agreement. I mean, you may have, in the rare case, the bug in the hotel room or the recorded telephone call, but generally, Your Honors, it is inferred from conduct. So, if you have a situation, as we have here, where all the facts from which the inference is to be drawn are established by clear and convincing evidence, it follows that the inference, which is merely an act of logic, follows from clear and convincing evidence. And therefore, even the agreement is proven in this case, not necessarily in every case, but in this case, by clear and convincing evidence, because the underlying predicate facts from which the inference is drawn are all established by clear and convincing evidence. Let me go on quickly to value. We have various sources of evidence on value. There's Duncan's two opinions, one on the income streams, the other on the value of business valuation of NGT. We have the evidence of Mr. Boltz himself, who then was a corporate owner. His opinion was $5 million. Duncan's was $2.7 million. For the income streams, $2 million for business valuation, roughly. A little bit shy, but not by much. And then the last point is the actual sale that took place by Mr. Ozen. He acquired a 10.8% interest in NGT for $270,000. And if you extrapolate that out, $270,000 equals 10.8%. $2.5 million equals 100%. That's his own admission, and he testified on the stand. I cross-examined him. He said, he acknowledged that was the value of the business. It's an admission against interest. It properly came in. Last, arising out of contract. I'm going to limit because you've got all the briefing, and it's a very familiar term to the court. But I do want to address the case that just came out and got filed as a supplemental citation by opposing counsel on Friday. That's the Simra case. Now, the Simra case is a memorandum decision only and therefore is not precedent. It can only be cited for its persuasive value. And in this case, Your Honors, I humbly submit it has no persuasive value. And I will tell you why I say that. There are two main points to it. The first point is that the duty breached must be contractual in nature. And I disagree with that as a definition of arising out of contract. That is not the case. There are a number of cases in which there was no contractual duty breached, and yet the cases arose out of contract. And let me give you the citations for them. The Teresia case, which we've cited, was a violation of the Magnuson-Moss Act. California Casualty, which we've cited, was one insurer's claim for equitable contribution against another insurer, and the only contract was that both were obliged to indemnify the insured. That's it. And last, the Hyatt case, which was a derivative action. I do want to mention the distinction between Dooley. The point is made, Dooley says you don't get fees in a fraudulent transfer case. I don't think that's quite what it says. I think what it says is on those facts, you don't get it. The fraudulent transfer statutes themselves are silent. They don't say, do you get it or you do not get it. But the ML servicing case is another fraudulent transfer case. It came out after Dooley, and it makes plain that depending on the facts, you can arise out of contract in a fraudulent transfer case, unless the court has questions. Thank you.
Good morning, Your Honors. Robert Mandel, representing Fred Ozen and his wife, Renee Cermak. I wonder if it would be all right if I sit down. I have a back issue. Would that be...
That's fine.
Thank you, Your Honor. Your Honor, opposing counsel began by letting us know that the first issue they were going to address was invited error, but I think the first issue they actually addressed was the issue of preservation of error, and so I'd like to just turn to that real quickly and address it this way. As Your Honors acknowledged, this judge was probably the person in the best position to assess whether or not a mistake had been made. And so when she was presented with the post-judgment motions, and she recognized that the instructional error had been made, she called the parties together and said, "We made a mistake." She then, during the hearing that followed, said, "I didn't catch it." That is, she's saying she didn't catch it, and Mr. Conant said, "I didn't catch it either," and the judge said, "None of us caught it." Of course, when you talk about catching something, what you're talking about is a mistake, and the judge understood that that's what it was. And when it comes to issues of waiver, it is a classic abuse of discretion question. The judge was in the best position to determine that no waiver existed, and she memorialized that in her amended under advisement ruling at IR 1115. There was no waiver here. There was a simple mistake. The judge recognized that after having provided an absolutely correct set of instructions applying the clear and convincing evidence standard to all 5 or 6 elements of the claim, but not filing it, was served, not filed. It was served because the judge in November of 2017 had asked the parties to exchange drafts of proposed instructions and come to an agreement that they could then include in their pretrial memorandum. The other side received it and they responded to it, and in their response, they acknowledged that the correct standard of proof is clear and convincing, and no, they did not apply it strictly to the issue of agreement. If you read their objection completely, they simply said the clear and convincing evidence standard applies to, and then they quoted Dawson versus Withicum, which is not a case that limits its discussion to simply the agreement element of the claim, but to all the elements of the claim. Although admittedly, Dawson v. Withicum speaks in shorthand, the best articulation of the elements comes out of the McLennan v. Hing case, which I'm going to refer to as Hing, because Hing is much easier to say repeatedly during this oral argument. Your Honors, counsel then moved to invited error. I'd like to point out a few facts about invited error that did not come through in counsel's presentation, but did come through in their briefing. First of all, they cited First Estate v. Diaz for the proposition that invited error is the usual analysis and that fundamental error is the exceptional rule in all cases of waiver. That is not what Diaz held. Those words are pulled out of context. What Diaz held was that although the fundamental error doctrine competes with the doctrine of invited error, neither doctrine should be given automatic precedence over the other. The issue of what the usual analysis is came out of Diaz's discussion of what the usual analysis would be in an instance in which you have a clear record showing that the person complaining about the error deliberately inserted it into the case. It's a very different message that the court was conveying. As importantly, Diaz confined its ruling to the unique facts of that case. I also want to speak for a moment about Robertson, State v. Robertson, which is the latest case out of our Supreme Court about invited error. And what is so important about Robertson is that Robertson really turns, as I would say, pivots this court's precedent, or the Supreme Court's precedent about invited error, back to the extreme caution that the Court of Appeals, this court, stated ought to be applied in the Lucero case, State v. Lucero. And it was in State v. Lucero where this court acknowledged that the purpose of the doctrine is to ensure against strategic gamesmanship, where the objective is to insert error into the case in order to profit from it on appeal. There was a case in between Lucero and State v. Robertson out of this court called Carruthers, was cited in the original principal brief by the other side, but abandoned in their reply, and rightly so, because while Lucero did make mention of how mistakes alone can also invite the invited error doctrine, I think that statement, which was dictum anyway, is not where our Supreme Court has decided to go.
Counsel, let me ask you, you
Yes.
heard me ask your counterpart
Sure.
about whether this case was really procedurally distinct from invited error cases, because we have a trial court looking at an issue, making a call, then realizing, hey, that was the wrong call, and then putting in measures, less than perfect, but measures that she had in her toolbox
Yes.
to try to correct that. And then it comes to this court. Typically, both invited error and fundamental error come to this court where nothing was raised with the trial court. What standard of review is appropriate for invited error in this case?
Well, it does add a complexity because the Rule 59 motion generally is an abuse of discretion standard. Of course, any legal conclusions the judge reaches in resolving that motion would be subject to de novo analysis, and if there were a de novo error, by definition, it would be an abuse of discretion. Here, you have to pick apart her decision. For example, with respect to her ruling on preservation, I believe the abuse of discretion error still stands. With regard to her ultimate conclusions as to which prongs of the fundamental error analysis are implicated, I think that's a mixed question of law and fact. And I have not seen precedent determining how this court would evaluate it, whether it would be de novo or abuse of discretion.
And almost always fundamental error comes up in a criminal case. Now, there's case
Absolutely.
law saying it can drip into civil, but that's not really the
That-
sort of origin of it.
Correct.
What are you familiar, and then let me quit interrupting, but of any Arizona case applying invited error in this procedural context? In other words, where the trial court realizes, hey, yes, I made a mistake, trying to fix it, and then it comes up to this court.
No, but if it existed, I would imagine that Court of Appeals would have written that they welcome that procedure, because what it does is it allows the judge who was closest to the events that transpired to make the decision, as opposed to requiring 3 judges who are reading 300 pages of briefing and 1,141 docket entries to figure out what actually happened, which is what we had in this case. So the short answer to your question is, Your Honor, no. And the long-winded point I was trying to make about invited error is that we are back now, if you look at our precedent, State v. Robertson, it is all an admonition to the trial bench to be extremely cautious in applying that rule. They want clear evidence from the record of an affirmative, independent effort by trial counsel to insert the error into the
But
record.
isn't that the point opposing counsel made, that that your side actually corrected or made changes to the instruction proposed by the court rather than proffering a different instruction, and so implicitly agreed and said, this is a good instruction, we want you to change it in this manner? Why isn't that an affirmative act that suggests that you injected this error?
I agree with counsel that this case does not stand on all fours with any prior one, and Your Honor's point is the point of distinction with the rest of the precedent that we have, that you do not have an example that I'm aware of, and I've read a lot of the cases, I know you have too, in which counsel has submitted an objection to the judge's proposed instruction, one that really should have come as a surprise to everyone, considering that everybody up until that point had advocated for a clear and convincing evidence standard, and the instruction came back without one, with the preponderance standard. So it made all the sense in the world for Mr. Konak to file an objection, and did so. It was only 2 days later that the red line came out, and he had mistakenly he was very much focused on the fourth element that he wanted to add to the instruction, which related to whether or not the defendant had, after the transfer, engaged in some additional conduct that would have made it more difficult for the plaintiff to collect. And that arises out of one of the elements that Hing discusses at the very end of the decision, where they say that an element of the claim is that there must be no suitable equitable remedy under the UFCA at that point. It's a long story, probably not worth getting into the details about, but the point is that trial court counsel was very much focused on that. They thought that was very important, and they simply overlooked the issue that they had just objected to 2 days earlier. If there had been something that had transpired between the 3rd of April and the 5th of April, that in the record that would suggest there was a reason for trial counsel to change their mind about the position they espoused in the objection, then we would have something to discuss. But there is nothing in the record to suggest that there was some reason to do so. The only possibility is that given the number of off-the-record conversations that were going on with trial counsel, and they were all the time, it is possible that the judge in that 2-day period said, nope, we're sticking with preponderance, and for that reason trial counsel left it in. We will never know, but of course if that's what happened, it would only reinforce the argument that the issue was not waived, but instead preserved. Let me get to fundamental error if my time still permits.
Could you address
Sure.
the argument that was raised that in finding, in imposing punitive damages, the jury essentially was applying a more rigorous burden of proof, and why shouldn't that inform us as to what the jury would have done with the correct burden?
That argument is totally flawed, Your Honor, and let me explain why. The jury was instructed that it could award punitive damages against Fred, Buzz, and I believe it was Suzanne Bolts, and Michelle, if it found that any of 3 different circumstances were proven by clear and convincing evidence. The instructions state that those circumstances are in the disjunctive, and one of those circumstances is, to put it in shorthand, recklessness. So recklessness, by clear and convincing evidence, can lead to a punitive damages award. Thus, it's plausible the jury based its punitive damages award on the recklessness element, and if that is so, then it would not have found it based on the element that I think the other side focuses on, which is intent to injure. Intent to injure would be the one they focus on because it's the one that perhaps overlaps to some extent with the specific intent element of the conspiracy claim. But we have no way to know that the jury found specific intent in granting the punitive damages, and so that argument doesn't work. But even if the jury based its punitive damage decision on the intent to cause injury prong, let's just assume they did, it does not follow that the jury would have found elements 3 through 5 or 6 by clear and convincing evidence if it had been properly instructed to apply the clear and convincing evidence standard. At best, it might be probative of the specific intent element of the conspiracy damages claim, but though even that is questionable because a conspiracy damages claim requires under Hing that each member of the alleged conspiracy have the specific intent to unlawfully transfer assets. Here, the trial court determined that as a matter of law, no reasonable juror could have found that at least 2 of these conspirators had that state of mind. The state of mind required to burden them with a punitive damages award. So you see there's even a disconnect between the specific intent, proof of the intent element, if they had chosen the intent element for punitive damages, and proof of the specific intent element if under the conspiracy claim, because the conspiracy claim requires proof that all of them had the specific intent. Punitive damages claim is specific to the individual. And at least 2 of these individuals, the court found, didn't have the intent, although the jury found them liable for conspiracy. They make a very similar argument, not with respect to punitive damages, Your Honor. Thank you. But with respect to the agreement, they assert that the flawed instruction, this is all about prejudice, by the way. We really didn't get into the issue of fundamental errors. It's really about prejudice. They're saying this was all harmless. We're saying it was prejudicial. That the flawed instruction didn't prejudice the individual defendants because the jurors inferred the existence of a conspiratorial agreement from the same predicate acts that formed the basis of plaintiff's fraudulent transfer claims against the corporate defendants. And since the judge gave them a clear and convincing evidence standard, it's all good. Everything's fine. Nothing bad happened. This argument is flawed for 3 reasons as well. The jurors were instructed they could infer an agreement from such circumstantial evidence as the relationship of the parties, the interests of the conspirators, or other circumstances in addition to the nature of the acts. All of those types of circumstantial evidence are extrinsic to the elements of the civil conspiracy, of the fraudulent transfer claim, okay? And so, therefore, the jurors they simply never considered those circumstances through the lens of the clear and convincing evidence standard. You simply cannot do this transitive property of clear and convincing evidence burdens. It's not a math equation. It doesn't work here. The logic of the argument is flawed for another reason. The jurors found the evidence of transfers clearly and convincingly proved that the corporate defendants engaged in UFTA violations. The fact that they may have looked at the same evidence to infer the existence of an agreement does not mean that they found such an agreement was proven by clear and convincing evidence. In other words, the fact that the evidence may be perceived as clear for one purpose, to meet one element, does not make it clear for all purposes and all elements. The evidence may be the same, but the weight it is afforded for different claims and different elements of claims may differ dramatically. Finally, the jurors were instructed that you're to use the standard of more probably true than not true for all claims in this case, except for those on which you're specifically instructed that the burden of proof is the standard of clear and convincing evidence. There's nothing in the record that suggests the jury disregarded that instruction. Plaintiffs, in conclusion, Your Honor, with respect to this sort of no prejudice argument, we think there's plenty of prejudice, and if you define prejudice the way our court has several times in different ways, is it possible, is the language that we have heard. Is it reasonably probable that the jury could have reached a different verdict if it had been properly instructed? Well, in light of what I've just explained, I think it is entirely. And by the way, the elements, this is one last point, the elements do not totally overlap. First, There's the element that the judge added in as number 4. There's no place whatsoever in the underlying fraudulent transfer claim. And also the fifth element. The fifth element requires the jury to draw a nexus between the damages that were caused by the acts and the conspiratorial agreement. It isn't simply that this is a one-element claim. If this were a one-element claim confined to the issue of agreement, then our jury instructions would say you may find a conspiracy claim, you may award conspiracy damages against this defendant if you find an agreement. That is not what they say. I'm told I have 6 seconds, and in that 6 seconds, I'd like to thank you for listening so attentively.
Thank you. Counsel?
Very briefly, because I've only got 48 seconds left. What counsel left out is the actual discussion of the instructions at the hearing. And it is clear from that hearing held that opposing counsel knew what was going on. The judge went over the instruction on conspiracy in depth. He made no objection again, which points out that he knew exactly what he was doing. The Carruthers case, we didn't abandon that. I will get so many words, and I had to be very parsimonious. The main point, Your Honor, when you get right down to it, is the facts were all found. And the facts relating to the judge's decision to grant a new trial are all established. It's the legal consequences that flow from it. So the standard of review has to be de novo. It has to be, because the facts are not in dispute. Not everybody objected. Well, I'm out of time, so unless the court has questions, I also want to thank you.
Thank you. Thank you both for your argument. We appreciate hearing from both of you. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.